Welcome back to Pace Law Firm, talking with Michelle Arzega, lawyer at Pace Law Firm, pacelawfirm.com. Michelle, thanks for stopping by. Today we're going to talk about limitation periods. In other words, if you get injured or something happens, you don't have forever to sue, do you?
No, you don't. You actually don't. A lot of people think that, I don't get a lot of clients where they come in 3 or 4 years after the fact, but it does happen. And a lot of people want to know whether or not they're out of time to bring a claim against a potential defendant. And the fact of the matter is, and generally speaking, you have a limited amount of time to bring a claim against a potential defendant. And generally speaking, that's under the Limitations Act. And you have 2 years from the date of your injury or the date of your loss to bring a claim against a potential defendant or defendants. Now, there are certain exceptions to that, but generally speaking, you should always take it as 2 years from the date of your accident. It is a lot of time, but a lot of people should be aware of that.
So how does that square with when you see those lawyers' commercials on TV and they say something about if you have mesothelioma from the mines and you wish to sue someone after so many years, how does that square with limitations?
Well, in terms of, you always think about the 2-year rule, and that's one of the exceptions that does arise. There is a lot of case law out there in Ontario as well as in Canada that talks about when a potential plaintiff becomes aware of their loss. And you were talking about a certain type of cancer that people develop over time that may have been caused many years before. And so probably a lot of people think, well, I'm out of time if it's the 2-year limitation period. In fact, it's not. A lot of the case law and a lot of our courts will accept the fact that when a plaintiff becomes aware of their injury or they develop this condition, that's when the 2-year limitation period, or that's when that 2-year time period starts to run. So let's say, for instance, you find out that you've developed this illness or condition, or this personal injury becomes serious enough after that 2-year mark of the initial cause. Courts will accept the fact that that the limitation period will start to run from the date that you discovered it. So if it happened 10 years ago and you figure out that 10 years later that it was caused by this event, your limitation period starts from the time you discover it.
Okay. What about things like, I've heard anyway, that there are limitations when it comes to, say, suing the city. So if you're on a public transportation or you're on the sidewalk and you trip and fall, there's certain limitations there as well, aren't there?
Absolutely. With respect to the city, because there are so many claims against the city and they'd like the opportunity to be able to respond to these claims in a timely manner, there is legislation under the municipality, for the municipalities, which allows them to have a 10-day notice period. So as soon as you realize that you've had this injury that could potentially have the city or any city as a potential defendant, you have 10 days from when it happened to notify the city clerk's office that you have this injury and that you intend to bring a claim against the city. Now, it's not a formal claim. It's just basically notice to the city within that 10-day period that they have to be aware of that this potentially could happen.
Now, if you miss that 10 days, that's it. There's no comebacks with the city?
There are certain exceptions to that. If you are if you aren't of sound mind, if you are a minor, if you have good reason for not bringing that claim with it, or bringing the notice of that claim within the 10-day period, they will make certain exceptions to that. For instance, if you're stuck in the hospital and injured and you're not thinking right because you have all of this medication pumped into you, then they will sometimes waive the 10-day notice period and see that as a reasonable exception.
Now, I noticed you mentioned minors. Are there certain considerations for the 2-year rule when it comes to people under the age of, say, 18, 16?
18.
Okay.
So that's another exception to the Limitations Act. The limitation period doesn't start to run from the date of loss. It starts to run from the moment they turn 18 years old.
Oh, wow.
So if they get injured at age 10, they have essentially 10 years to bring a claim against any potential defendant.
Excellent. People can get in touch with you to learn more information. How?
At my direct line, which is 416-734-0447. I'm always accessible by email as well, marzaga@pacelawfirm.com.
Excellent. All right, Michelle, thanks for coming by. We'll talk to you again soon. Everyone tune in at pacelawfirm.com and our YouTube channel, as well as facebook.com/pacelawfirm. We'll see you next time. Bye.